As long as there is a federal government, there will always be attempts to improve it. Most recent reforms have involved sunshine and sunset laws, privatization, and whistleblowing. The Government and Sunshine Act of 1976 requires all government agencies to conduct their meetings in public sessions. Sunshine laws now exist at all levels of government. The 1966 Freedom of Information Act requires most federal agencies to open their files to requests for information by citizens. Reporters and investigators have greatly benefited from this legislation in uncovering corruption, waste, and incompetence. By 2001, the repercussions of open disclosure were questioned, and limits were placed on the release of any information that could conceivably have been used by terrorists. Within weeks after September 11, 2001, federal agencies removed thousands of documents, maps, blueprints, and diagrams from public libraries, reading rooms, and internet sites. Sunset legislation requires that programs be limited to a set schedule, reviewed by Congress for their effectiveness, and ended if it fails to reauthorize their funding. Privatization occurs when certain government services are contracted out to private businesses in the name of efficiency and cost savings. It's most often seen at the local level. However, it can be controversial, particularly regarding barriers to competitive bidding and lack of oversight. And of course, some functions are difficult to contract out, such as police services and fire services. State governments and local governments are now devising methods to improve productivity and efficiency, including worker incentives and agency bonuses. The Government Performance and Results Act of 1997 requires all federal agencies, except the CIA, to describe their goals, broad or narrow, and create mechanisms for evaluating them. A whistleblower is someone who brings to public attention gross governmental inefficiencies or illegal actions. Civil Service Reform Act bans reprisals against whistleblowers, and it set up the Independent Merit Systems Protection Board to protect against such actions. The Whistleblower Protection Act of 1989 further protects federal employees who report serious problems. It set up the Office of Special Counsel to investigate complaints by whistleblowers of any mistreatment after reporting such inefficiencies. False Claims Act of 1986 encourages federal workers to report fraud within bureaucratic agencies by offering monetary rewards for claims verified in court. And despite these legal endeavors, whistleblowers may not receive much protection. Many who go to the OSC are no longer employed by the agencies they report, pointing to questionable practices. And in 2006, the Supreme Court ruled in the Garcetti case that restricted lawsuits from public workers, ruling that within the workplace they are acting as employees and not citizens. So Garcetti places restrictions on lawsuits from public workers because within the workplace they're acting as employees and not citizens. Congress lacks the expertise and resources to administer the day-to-day initiatives of all its programs, so it uses enabling legislation to delegate this responsibility by creating new agencies to put these laws into practice. Since it is rare that laws are so precise that there is no room for questions concerning interpretation and application, the bureaucracy is pressed into the role of an unelected policymaker that interprets laws and statutes. Rules and regulations proposed by agencies are published in the Federal Register, so interested parties can review and comment on them before they are finalized. 60 days must pass before the rule goes into effect, allowing businesses, individuals, and state and local governments to request that it be revised or even overturned. After 60 days, the rule can be challenged in court, often on the grounds that it misrepresents or exceeds the agency's mandate, or that the rule itself is arbitrary and capricious. The way the agencies implement, administer, and enforce laws can lead to controversy and lawsuits. There are case after case where that's the example. In an attempt to cut time-consuming lawsuits challenging government regulations, federal agencies now encourage interested parties to take part in drafting regulations. This negotiated rulemaking, endorsed by the Negotiating Rulemaking Act of 1990, is monitored by a neutral third party and often requires that all participants accept the committee's decision and agree not to challenge in court. Many legally binding regulations are initiated by agencies as they carry out the provisions of broad legislation and translate law into action. In doing so, bureaucrats become policymakers. Bureaucracy's role has historically been viewed as part of an iron triangle, a three-way alliance involving legislators, interest groups, and federal agencies that influence policies that benefit their respective interests. So the Iron Triangle is an alliance among legislators, bureaucrats, and interest groups. However, Iron Triangles no longer really describe today's complicated web of relations. The bureaucracy is larger, Congress has more subcommittees, and interest groups are more numerous and powerful. Issue networks better describe the complex situations in which legislators, interest groups, businesses, their bureaucrats, scholars, and reporters who share a position on a given issue may attempt to exert influence on the executive branch, on Congress, on the courts, or on the media to see their policy position enacted. Congress surely faces challenges in directing today's expansive federal bureaucracy. It creates agencies when needed, specifies their responsibilities and tasks, reviews and investigates their work, and controls their funds. It can wield control through enabling legislation, the power of the purse, and oversight. It can also enlist the help of the Government Accountability Office and the Congressional Budget Office. So Congress, in many ways, can make its positions known and enforce those positions. That concludes the lecture for this chapter. Please look under course documents for the additional assignments for this chapter.